So what we had Nancy Edmonds, who admitted during Doreen's trial, last trial, that she's never read the CTC, and yet she made a finding of what it says. And her finding was that CTC says that only federal, state, and local government workers are subject to the income tax.
How can you do that?
Because Robert Metcalf, the DOJ attorney who was responsible for accomplishing this narrative spin, told her that.
It's called the dry lab, and I used to get E's for that.
And so Edmonds just did it. All of that is being used to generate the spin and the narrative against the truth, to frighten people away. Because Brian hit the nail on the head here. When enough people learn the truth about this, this whole nasty, ugly little impoverishing, legally ruinous gig falls to the ground. Just like that. If everybody in America read Cracking the Code tomorrow, that would be it. That would be it. It would be over. Did that happen to us? No. No notice of deficiency, no audit, not even a contact, not even a letter saying, oh, we think there's something wrong with your returns. Because of course they didn't think there was anything wrong with their returns. They knew perfectly well there was nothing wrong with your returns. They had scrutinized those returns so heavily. Brian, you sat through 2 trials. You saw the documentation. I don't know if you paid attention to that evidence, but we got a half dozen poking notices at each of those refunds over months of time, as they fussed with them and looked at them and made this decision about them and that decision about them, and eventually issued them forth. And it was a long, elaborate process. And then not one word contradictory to any of that before this lawsuit was filed, saying, oh, we made a big mistake, and and we want to, by the way, have you guys ordered to replace your returns. So, the lawsuit that Robert Metcalf brought in 2006, they initially just made this complaint saying, we didn't know that the Hendricksons had been paid anything, and being misled by their returns, all just, poor innocents that we are. We just issued these refunds, and it was all a big mistake, and now we've come to realize the truth, and so we want, the court to, order them to give us back the refunds. And we responded. Beginning, our response was a motion to dismiss on various grounds. A couple months later, that motion to dismiss just hanging fire in Edmonds' courtroom, no response to it at all from Edmonds. The government files another motion, a motion for summary judgment, and just says, we think that you should just declare us to be the winners here. And attached to that motion for summary judgment were 2 declarations. One from, or 2 government personnel declarations. One from someone named Shauna Henline, who was an officer at the Ogden Frivolous Return Program, who carried on at great length about what qualifies as a frivolous return and so forth. And in the course of her, whatever it was, 10 or 12 or 14-page declaration, carefully does not declare our returns to be frivolous. Even though, ostensibly that's the only reason for this declaration to be included there. She talks about how many returns, similar to ours, her office has seen, and so forth, but and how worried the government had gotten about returns like ours, and the vast numbers of them that were beginning to show up by beginning in 2005 in particular. But carefully does not call our returns frivolous. Our returns have never been deemed frivolous. And then there was another one by a person who acknowledged they were using a pseudonym. No explanation for why this is. This was just an examiner. But used the pseudonym of Terry Grant and and it included an examination report that purportedly did calculations, liability calculations on our earnings, treating everything that had been earned as being taxable, of course. In other words, she just took for granted that the information returns were accurate, were correct in what they said. But said in her preliminary remarks, this is not a formal examination. Consequently the form is unsigned, and it's meaningless. I mean, it's no better than if they had the janitor, slap a few things down on paper and hand it in. And the point of the takeaway from this, the significant things, what world is it credible that in this situation they have the one declaration saying there are now thousands and thousands and thousands of people that are filing returns just like this, and the IRS is really concerned about this, and this is way out of hand, and it's a big deal, and yet they can't get a signed formal examination report declaring our earnings to be subject to the tax. This is ridiculous. This is ridiculous. But that's what was presented. And on the basis of that unsigned, declaredly informal document, Edmunds just took the numbers off it and said, oh, okay, I'm finding that these things are true, and I'm finding that the Hendricksons owe this money, and by the way, I'm ordering the Hendricksons to say these things are true over their own signatures on forms replacing the ones that we're pretending don't count for anything anyway. Which would normally mean, well, why would you need them replaced if they don't count for anything? If they're just like, pieces of scrap paper, like you're trying to suggest, then why would they need to be replaced with anything? And if you guys actually, have grounds for your alleged conclusions or your assertions, then why do you need anything from the Hendricksons? I mean, it's not one bit of this makes it a tax court. No, Edmund's not a tax court judge. This never went to tax court. That's one of the things. They never issued a notice of deficiency to us. No, it's a district court judge that they brought in on an alleged equity argument. They came in saying, the Hendricksons owe us these returns saying what we think is correct, or at least are saying is correct, even though we don't think it enough to have ever signed a return of our own, even though the law says we have to if we think what the Hendrickson said is wrong. Okay.
Now, you said if someone gets a notice of deficiency, what normally takes care of that is informed return sent to that.
Generally speaking, that's how it works out. And I have lots of examples of that on the website.
But you already sent them your...
Yeah, I know. There's a left hand doesn't know what the right hand is doing ploy, it seems. I'm not in their heads, so I can't say exactly what's going on, with this stuff, but because what you say, is intuitively, this seems kind of self-evident, somebody has the return sitting right there, what's the point? Well, here's the point. It's kind of like when a frivolous notice goes out, even though it doesn't say so, in my opinion, this is an invitation for acquiescence by silence. This is an invitation for, you to not answer and somebody to say, well, we gave them an opportunity to rebut our assertion that their return was frivolous, and they didn't say anything, so we're operating on the basis that they've agreed that their return is frivolous. Unfortunately, as obnoxious as it is, you have to answer this stuff, and the same thing with that notice of deficiency. Okay, yeah, you sent your thing. Okay, well, I'm going to take a shot and see if you really mean it, and here's my dump on you to see what you say.
So basically, you're just sending another photocopy.
You're saying, I really mean it.
That's what you had sent in earlier.
Yeah, that's what typically happens. Yeah.
Pete, on the other hand, this could be a great opportunity in a way, because if for you to prevail at the appellate court or even the U.S. Supreme Court level, you could single-handedly take down the entire system.
Oh,
so the question here is, how could we help you, to perfect this?
Good, great question. Thank you. Wonderful question. And you're right. That is, it all becomes the point of the spirit in some ways. The way to help is to do that liberation journalism that I was talking about at the very beginning. I I don't have that loud of a voice. And frankly, my saying the voice, when I'm the one that's the target of the attacks, my voice, even the things, the degree to which I am able to use my voice, is diminished in effectiveness a lot. People who are arguing their own case, they're not taking us seriously as, it's presumed there's a bias. I mean, there's obviously it's just, that's human nature. So I need other people to be doing it, to be saying these things. And that makes a big difference. Yeah, right.
I talked with Shane after work, okay?
Yeah.
And Shane and I well, he's going to do most of the work, but I'm going to do my part too. But his idea is to continue along the vein of these Pontiac Tribune columns, which is a virtual newspaper, really. It's like a local freedom type newspaper. It's a web newspaper. It looks like to the outside world,
It looks like the Washington Post.
It looks like, yeah, it's a pretty attractive.
It's a great example of the reality of the internet, that,
Exactly.
a small operation can look just as big.
And this I think could go viral to the extent that we do penetrate the alternative media, particularly like, Jones and Company and so forth. So a lot of those columnists that write, a lot of those commentators that talk for Jones and Company. I mean, once you get one of those, you get like a Watson or or whoever, one of those guys, they come along and they say, yeah, I know you've talked or you've written them a lot, but I think if you get this media thing, kind of like what Shane has in mind, you get that going and you sort of build this appearance of a mass movement.
Yes.
Then if you amplify that through the alternative community, you're really onto something here. This is extremely powerful, and it's exactly what they are trying to. They're terrified of.
Yeah. Well, let me explain something about power. Let me explain something about power. First of all, I want to agree with you, everything you said, and I'm excited about that project that Shane has. He sent me an email about it yesterday, and that's great. It's the kind of thing that needs to be done. It needs to be done not just by Shane, though. It needs to be done by everybody.
Well, we all need to do it, but I'm just saying.
Yeah, no, and this is one.
The ice.
To Tyson's question, to repeat that answer, it is. I have characterized CTC this way before, and I say it with 100% sincerity. It is the sharpened steak above the vampire's breast. It is right there, ready to work. It just needs people's weight piled on top of the butt end of it to make it happen. That's all that's necessary. And that just takes cracking the ice of media so that somebody suddenly recognizes, you know what, this is where my Pulitzer is coming from. And, I don't frankly care anymore about, the fact that maybe I'll lose my, entry card to the executive washroom. Because ultimately, that's how truth works out. It never can be, completely suppressed forever. And eventually somebody recognizes that, it's inevitable, and it might as well be, and better would be them that, gets the credit for, being the Woodward and Bernstein that, gets to write the books for the rest of their life and go on speaking tours because they bucked the system and
the more I thought about it now, CTC is sort of a convenient truth. I mean, it is really something that can be the vehicle for this. Effectively would be just a rejection, a total rejection of this corrupt.
It's the biggest back out. It's the biggest back out that there is, and it is that way because the founders designed it that way.
And plus, there's the self-interest angle.
No, that's what I'm just getting at. That's how they designed it.
And it works.
The founders were big Adam Smith students. They understood Smith's economics and his logic. They understood the invisible hand. Their whole gig was diffusion of power. That was their whole brilliance in their political structure, was recognizing that the only way you're going to be safe from corruption, tyranny, was to diffuse power as much as you could. And so they set up structures where there had to be power. It competed with the other structures where there had to be power. And they left all the power they could in the hands of the people, where it was the most diffused that it could be, and where it belonged in the first place. These guys were not, undoubtedly, there were a lot of political hacks in that, and a little political hackery in what they did. But at the same time, there also was not. Bear in mind, this was the generation that actually did go out and take bullets in the belly to make this happen. These were not the political hacks that came afterwards, who were riding on the sacrifices that the founding generation went through. These were the guys who actually went out and faced bayonets and made it happen. They were serious. When they said things like, power is inherent in the people and that's where it comes from, they actually meant it. This was not rhetoric that, came from the political hacks 25 years later and, into the future. These were people who actually meant that. As much as they are maligned and dissed in today's society, and the reason that they are, by the way, the reason that they are is because what they did really does restrain the government. And so the people that are enthused about the status quo, they want to trash the founders and trash their sincerity and trash the product of the Constitution because they don't want to be restrained. They want to be liberated from what the Constitution really does. But the founders, they were big on this diffusion of power, and so they left two critically important things in the hands of the people. They left the power of the sword in the hands of the people. They did that in two different ways. I'm not talking the Second Amendment. That's one of the ways, in a manner of speaking. And anybody that trashes the Constitution and argues that it was a scheme by the political elite to fasten some kind of subjugation on the people should read the Second Amendment. Anybody that thinks that some elitist Illuminati conspiracy was trying to retain power for themselves against everybody else, explain to me why then every farmer in town, every farmer in the hinterlands was given the specific right to keep and bear military equipment. And specifically, according to the founders' words, for the purpose of putting a bullet in the belly of anybody in political power that was oppressing them, that was abusing them, that was exceeding their authority. There is no way that those two things coexist. There is no way. People who trash the Constitution are full of beans. They are deliberately trying to take from you the biggest protection that you have against an accretion of power, oppression, tyranny, and big government. The Constitution is the defense against the political elite. It is not the tool of a political elite. It is your best friend. But that was only, that's not the power of the sword that I was talking about. The power of the sword I was talking about was the jury. By jury provision, the founders said, anytime the state is wanting to exercise force against one of you, you're the ones that get to say whether it happens or not. Power of the sword in the hands of the people. Big diffusion. Here was the other one. The power of the purse was also diffused into the hands of the people, and it was done by the mechanisms of the tax structure that was set up. No capitation or other direct tax without apportionment. Apportionment is a really limiting rule. It requires a lot of political accountability when it's exercised, when a direct tax is actually implemented, which we've had over the course of our history. We've had it happen a dozen times or so that a direct tax, abortion direct tax was implemented. Big chunk of money raised on each occasion, because that's how it works, and because it is politically accountable. It's not an open-ended thing where you just, push the button and the money just keeps rolling in for the next 35 years. It's a one-time deal. And you can be politically punished for, doing it wrong or badly or too much or whatever. The only time it got done was to retire some kind of big debt after a war or other, significant need. But it's very limited, very limited. And the other kind, the kind that isn't subject to that sort of limit, is indirect taxes, excises, duties, and imposts. And those are in the hands of the individuals to control how much of it they pay. Those are the ones, that's in your hands. The people overall, that power is diffused among the people. They get to control how much fuel goes into the federal government. It's that simple. Even Alexander Hamilton, described that process, and that's the reason why the thing was set up that way. It would be a self-regulating structure. And it comes back to Adam Smith and the respect that the founders had for Adam Smith's logic in economics. He had spoken of the invisible hand, how each person looking out for their own self-interest benefits society overall. Not because each person cares about society, because they didn't. I mean, his whole point was, you're looking after your own interests. You're trying to make money. You're trying to, but you know what? When you're operating in a properly designed structure and you're trying to make money, the only way you can do that is by doing stuff that benefits everybody. That's the only way you can make money. And the same thing is true. The founders deployed that same kind of reasoning in the tax structure. You looking out for your interests benefits society because it operates as a regulating control over the size of a state that otherwise would become big and dangerous. That the founders did not want. They did not want a central state that was big, because a big central state is a dangerous central state. You let things creep into the center like that, it becomes arrogant, it becomes uncontrollable, it becomes corrupt, and then it becomes a threat to liberty.
You say that there have been direct proportion taxes historically in America.
Sure.
When was that? When were those?
After the War of 1812, we had one or two. After the Civil War, or the War of Northern Aggression, or the War to prevent Southern independence, or however you want to put that one. We had about a dozen. I can't list all the time. At the back of CTC, I have one of them in there that was in 1798, and it actually, was the whole tax bill.
So that's really important, because I think a lot of people think that the 16th Amendment, is that right? Is the income tax amendment, correct?
Well, no, it's an amendment that has something to do with the income tax. It's not the initiating income tax.
Well, no, but a lot of people...
People tend to call it that, yeah, a lot.
Well, but the 16th Amendment is the one we're talking about, right? Isn't that the one that supposedly, that a lot of people think?
A lot of people are very, very carefully and deliberately led to believe that's what initiated the income tax.
And,
yes.
And a lot of people believe that it repealed Article 1, Section 9. Or
That's high school history books even say that.
Well,
Special note to say that.
they won't say repealed, but what they'll typically do is there will be an asterisk after Article 1, Section 9, where the capitation rules, and both places where the capitation and apportionment rules are laid out, there will be an asterisk, and then at the bottom underneath it'll say C 16th Amendment. It doesn't say repealed by or even modified by typically. I mean, it may be that it's put that way in some texts or whatever. Normally what I see is the C 16th Amendment, which is a cagey way of doing it, because
the
implication is that it implies that the 16th Amendment modified or affected or did something about the direct tax provisions, even though the Supreme Court very explicitly said it did nothing to them. It had no effect on those requirements whatsoever. And they said, in fact, if it did, we'd have to rule the 16th Amendment unconstitutional, because it would create a conflict between two portions of the Constitution that is intolerable.
But this is probably the key point for a lot of people to convince them. I mean, I want to say educated people, because their view is, because of all the propaganda they've heard, that income now is or that the income tax is, it permits, or the 16th Amendment permits direct taxes, of which the income tax is one. you know?
Yes.
I mean, that's what most people think.
Yeah, and then there are some confusing court rulings from some appellate courts that, you know, lend themselves to some of that confusion, and they're made much of by the people who want that confusion. Understanding that the 16th Amendment did not initiate with, or that the income tax did not initiate with the 16th Amendment, actually answers almost all of that confusion.
True.
It requires a little thought, but when you have acknowledged, or when you have learned that the 16th Amendment did not initiate the income tax, that the income tax actually existed for 40 years, 50 years prior to the 16th Amendment, you cannot maintain a misunderstanding of the nature of the tax. I know that's a big statement to make, but it is one made, you know, from someone who has lived and breathed this subject for many years, and I'll say it again, as flatly as I can say it. If you integrate into your understanding that the income tax predates the 16th Amendment by 50 years, or even by 20, but in fact it's by 50, and was sustained by the courts as a valid tax, you cannot misunderstand the nature of the income tax today. You can't.
It's involuntary slavery, is that what you're saying?
No, it's the tax existed and was upheld as a valid tax prior to the 16th Amendment, meaning that it was upheld as a tax that did not require apportionment. What did that mean? It means that it's not a competition, it's not a capitation. And it's not a tax on all that comes in. It's not, it has to be, it has to have been a tax that was amenable to administration without apportionment. That means an excise, impost, or duty. That's what it is.
Then Pete,
And the 16th Amendment didn't change that.